Hey everyone, Attorney Matthew Legan Sanchez here. Today let's talk about how restraining order courts and child custody courts interact in Albuquerque, New Mexico. To begin, it's necessary to know the terms that you're going to be working with. Your restraining order court is called the DV court. Now the custody court or divorce court is called the DM court. And these are separate courts, but people that aren't used to the process or rookie attorneys, they will confuse the two courts. Apples and oranges, DV court, DM court, but sometimes attorneys or parties to the case will make it a fruit salad and combine these courts. So first you're going to need to know that there's a difference between the two courts, a DV court and a DM court. A restraining order of protection begins when a petition for order of protection is filed. When the petition is filed, if there's reasonable grounds in the petition to show that an act of abuse occurred, the court can issue a temporary restraining order, and this temporary restraining order can be issued without a hearing because it's an emergency order, and it can grant one parent sole legal custody while the temporary order is pending. Under New Mexico law, there must be a hearing set within 10 days of the temporary restraining order being granted. However, often for good cause shown, this temporary hearing, the 10-day hearing, can be continued. So sometimes there can be a temporary restraining order and it take 2, 3, or more weeks for the actual hearing to take place. And during that period of time, the temporary restraining order will control and it will supersede and override any custody orders in the DM case, the custody or divorce case. Are children involved with the restraining order? If so, then the temporary restraining order and the hearing can also involve children. The temporary restraining order can deal with custody and timesharing on an emergency basis. Now, at the restraining order hearing, the 10-day hearing, if a restraining order is entered, then the court has jurisdiction power to decide emergency timesharing, temporary timesharing. And the DV court, the restraining order court, can decide this temporary timesharing for a period of 6 months. It has jurisdiction. It can then override the DM case, which is the ongoing case, with its jurisdiction that's limited for 6 months to decide custody and timesharing issues. But that's only if a restraining order is entered. If the restraining order is dismissed, then the temporary restraining order is also dismissed. And then the DM order, the custody or divorce order, that is the applicable and enforceable order that takes place when the restraining order is dismissed. When the restraining order is entered and the court has 6 months to decide custody and timesharing on a temporary basis, that's just a band-aid. It's not the long-term fix. If there's not another case open, a divorce case or a custody case, then you're going to need to open that other case, the DM case, for a long-term permanent custody and timesharing order. So for instance, if you were never married, you need to file a petition to establish paternity, custody, and timesharing. In that DM case, the custody case, then the court can decide permanent timesharing and custody. Likewise, if you're married, you need to file a petition for dissolution of marriage so that your DM case, your divorce case, can handle your custody and timesharing issues through the parenting plan that's needed in order to have a final decree of dissolution of marriage. Do you already have a DM case established and there's already a custody order or a parenting plan if it's a divorce? If so, if a restraining order is entered and there's a temporary custody and timesharing order, you're going to need to reopen the custody or the divorce case and file a motion to modify custody or timesharing. Now, with a motion to modify custody and timesharing, you have to show that there's been a big change in circumstance, a material change in circumstance. And here, if a restraining order is entered, there's not really much of a bigger change in circumstance, so the court is going to need to reevaluate the existing timesharing and ultimately what timesharing and custody best serves the child. Restraining orders are often used when there's a custody or a divorce case to preemptively gain leverage in the divorce case. Now, for instance, let's say that there's a divorce case pending, or you're just right on the verge of a divorce case becoming a reality. In that situation, one parent may file a restraining order to get you out of the home and also to get temporary custody, because if one parent is granted temporary custody and if ultimately a restraining order is entered and possibly the court then gives supervised visitation or minimal visitation to a parent, that creates what's called the status quo. And the status quo in your case, in your divorce or your custody case, will highly influence what the court's going to do moving forward. Think of the status quo as momentum or a ball rolling. And once that status quo gets building, once that boulder gets moving, the harder it can be to stop, and potentially the more likely that your family court judge is to just go with the flow, make that the temporary order, and then potentially get a third party involved, such as a guardian ad litem or court clinic. When there are severe allegations of abuse, neglect, mental health issues, or any other issue impacting the child, particularly if the child's making disclosures, they're making disclosures that I don't want to go back to my mom or dad's house because the home's not safe, there's domestic violence, they're drinking and driving with me in the car. The court in these situations is going to need more information. The court process has evidentiary rules that make it very difficult to introduce specific information. Maybe it's the counselor or therapist statements, maybe it's the child statements, maybe it's hearsay, whatever it is. The family court system, for one, doesn't have enough time to set all day hearings for everything, or two, it's limited on what can come in through the rules of evidence. So often a GAL, a guardian ad litem, will be appointed to investigate the case, talk with the child, talk with collateral third-party sources, gather information, talk with the therapist, and then make recommendations. Likewise, court clinic may need to become involved in the case. And court clinic is a process, it's a service offered by Albuquerque courts where a clinician, which is basically a social worker, will interview the parties and then make recommendations to the judge on the appropriate time sharing. So your case, if it ends up in the DM court, there probably will need to be a guardian ad litem or a court clinic to flush out the more complex issues. Do you still have questions about how a restraining order impacts a custody or divorce case, or the difference between a DV court and a DM court? If so, call me. Call attorney Matthew Legan Sanchez. I have handled more restraining orders involving custody and divorce issues than any attorney that I know. I've been handling restraining order and divorce matters for 16 years. Talk to an attorney that knows what they're talking about. Don't talk to an attorney that's just faking it till they make it, and they themselves don't understand the dynamic between these two courts. Call 505 Sanchez today.